Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer, and I want to start a series of videos going over some of the important rules of evidence, particularly when we are dealing with a debt collection lawsuit. So a debt buyer such as LVNV or Midland Funding, Midland Credit Management, Portfolio Recovery, whoever it might be, they've sued us on an old credit card debt. What are the rules of evidence that we can think about to help us if we're going into trial? Now, this is for lawyers that maybe don't normally go into court, and it's also for those of you who do not have a lawyer and you're representing yourself. Now, I'm going to use the Alabama Rules of Evidence as an example here. We could use the federal rules of evidence, but each state will have its own little kind of tweaks on the rules of evidence, and you'll even see that here. But this will give you a starting point to do your own research to see, okay, what applies in your particular case. So this is Rule 106, and in most states, the numbering system will be very similar. So this is remainder of writings, and we're not really going to talk about recorded statements, just really the writings. So the rule is very short, and then we'll look at these committee notes, which kind of explain what's the purpose of this rule. So it says, when a party introduces part of either a writing or a recorded statement, then the adverse party may require the introduction of the other part of the writing that ought in fairness to be considered contemporaneous with it. Okay, so let's go back and look at this rule. So a party, that would be, for example, LVNV or Midland Funding, Midland Credit Management, Portfolio Recovery. It introduces a part of a writing. So not the entire document. If they introduce the entire document, we don't need Rule 106, but just a part of a document. Then the adverse party, that would be you, because you're adverse, you're opposed to the debt buyer that's suing you, may require the introduction at that time of any other part of the writing that what? That ought in fairness to be considered contemporaneous with it. So what it's saying is, let me use a different context. Personal injury, because I've been doing personal injury for 25 years. So car wrecks, you could think of it that way. So I introduce one page out of 50 pages of emergency room records that my client had after the wreck. So the wreck happens, goes immediately to the emergency room, generates 50 pages of medical records. I put in one page into evidence. Well, the other side, the defendant that I've sued, in fairness should be able to say, well, look, John put in one page of the medical records from the emergency room. Let's put in the rest of them, okay? Because one page may not give us the complete picture. And they can require that it be introduced at that time. So I put in the one page, the other side can object and say, Your Honor, based on Rule 106, we want all the emergency room records put in. So let's think about it in terms of a debt collection lawsuit. Here's kind of the classic example. So maybe I'll give you two examples. So Portfolio Recovery says, here's the bill of sale. This proves we bought it. Because, we talk about this. The debt collector has to prove that they own the debt. Not just that you owe it, but that they own it. And so they say, here's the bill of sale. And we say, well, Your Honor, we object to that based on Rule 106 unless the entire document is put in. And they go, this is the entire document. We go, no, this specifically says it's Exhibit A or B, and it says this is part of the credit card purchase agreement. They'll have some name for it, and sometimes it literally is just the credit card purchase agreement. And so obviously this bill of sale is just a part of, it's just a piece of a bigger document. So we say, we want the whole document introduced. And of course, then they have a complete come apart. If you're not from the South, that just means they go completely crazy, falling apart here. And they say, Judge, we can't put in the other stuff. That's top secret. Well, it doesn't matter. So you go back to my personal injury example. My medical records are very private, very confidential. But if I'm suing saying that I've been injured and I put in part of my medical records, well, then the rest of those medical records go in. You see? So they put in the bill of sale, then they can't go, well, the rest of it's absolutely top secret. We would never let a consumer see it. And truthfully, at least every time I've had this come up in trial, the lawyer will be going crazy about this. And I'll say, have you ever seen the full purchase agreement? Well, no, they don't allow us to see it. Interesting. So they don't even let their lawyer see it. But the point is, if they put in the bill of sale, my judgment is, my opinion, what I've argued for, I guess I've been doing these types of cases for 15 years now, is they got to put in the whole document. And that's exactly what Rule 106 describes. Now, this is commonly called the Completeness Doctrine. Okay? And so most judges, particularly if they're maybe in their 50s or 60s or 70s, that's how they know it. The Completeness Doctrine just means you put in part of a document. You should be able to, the other side could say, no, put in the complete document. So let's look at these committee notes. And this is not part of the rule, but it explains the rules. And these have a lot of weight. And now this is specific to Alabama, but if you're in another state, you look up your rule and you'll probably have something similar. And so it says, look, this is a specialized application of the common law completeness doctrine. And this is a famous book on evidence called Wigmore on Evidence. And it says, look, let me get this highlight. When one party introduces a portion of a writing, it is deemed only fair that the other party be allowed to have admitted any other part of the writing that in fairness ought to be considered. Now, it says it's a rejection of that portion of the federal rule, so Federal Rule 106, that expands the historic doctrine of completeness to include the admission of any additional writing that ought in fairness to be considered. So the federal rule would say, if they put in, let's go back to my personal injury example. I put in my emergency room records. Well, let's put in medical records from a week later. Okay, well, that's not the historical usage of the completeness doctrine. The completeness doctrine talks about one specific document. So if a part of document A is put in, well, then the rest of document A should be put in. And that's how Alabama limits it. Now, your state, again, may be the same, may be different. That's why you have to look it up. And so this is saying it's traditionally been recognized in Alabama law. So here's a case from 1979 that says, we have long recognized this. And so here's a specific application to depositions. And this is saying it's basically the same as Alabama Rule of Civil Procedure 32A4, which provides that if only part of a deposition is offered, then the adverse party may require the party introducing it to introduce all of the deposition that should be in fairness considered with the part introduced. Do you see the common thread here? If you're putting part of something in front of the jury, then the other side can say, no, let's put the whole thing in front of them. So go back to my example of the medical record. Let's say that I only wanted to introduce one sentence from one page of the medical record from the emergency room. Well, obviously you can't just put in one sentence, right? I mean, it's like, hey, we need some context here. And that's all this rule is saying. And so it does say that the trial judge has considerable discretion, okay, in terms of what in fairness ought to be considered. So this is where you have to argue. You have to explain to the judge, here's why it's important. So we'll go back to our bill of sale and purchase agreement, and I'll do a video where I show this kind of directly on the screen. But you'd say, well, look, the bill of sale talks about there are no representations except as recorded in the credit card purchase agreement. Well, we've got to look at that to see. And hey, this is an exhibit to a bigger document. We've got to see what that bigger document says. Okay, so this says it only applies to writings and recorded statements. So no impact on unrecorded conversation. So that would be a different set of rules. So we don't want to use this rule where it's not supposed to be used. Instead, we focus it on a portion of a document has been introduced. Now, let's see the rest of the document. That's what this rule is about. All right, so something else where this is part of the completeness principle, but this is outside Rule 106, is when a party whose admission has been admitted against him or her, and this would be under an exception to hearsay. And we'll talk about hearsay in a different video. May prove all that was said at the same time as the admitted. So it's saying, look, that may be part of the law, but that's not Rule 106. Rule 106 is focused on documents. And the reason I'm stressing this is because sometimes when you bring this up, the collection lawyer go, oh, well, that has no application here, and it's not really talking about No, it actually is only talking about documents, okay? We're not talking about other documents. We're not talking about depositions. We're talking about a document, whether that's 1 page or 1,001 pages. A document. There's a portion that's been admitted. Now let's put the whole document in. That's what we're talking about here. So this also has some instructions about timeliness. Okay, so here's what we mean. So what this is saying is that the other side can require that the whole document be admitted at the time that the initial portion of the document's admitted. Well, why is that? Because there's a belief that a delay in providing the complete evidence will render it less effective. So let's think about not in a debt collection trial, but a 3-week-long trial. So that's the longest trial we've ever been involved in, 3-week-long jury trial. Let's say that one party wants to introduce something on day 1, and the other party is not going to have their ability to call witnesses and put evidence in until day 17. Well, that's a little far away, right? Or day 12, or day 5, or day 3. You got all this time in between. And this is saying, look, we believe that if the completeness doctrine, as described in Rule 106, applies, then the other side should be able to get the whole document in right then, immediately, not having to wait. Now, in a debt collection trial, these are usually pretty short. Maybe they're 30 minutes, maybe they're an hour, 2 hours. Okay, it's not as big a deal, but again, it's just stressing to us how important it is and how the law views the idea that if part of a document goes in, it's so important that the whole document goes in, and it goes in right then, immediately. Now, this also says, look, this does not limit your ability to go into the same document on cross-examination, or you can wait to your own case. So you don't have to do it immediately. It's just saying we recognize normally it's so important that the whole document go in immediately that you have the ability to require that. See, normally in a case, let's say portfolio recovery, they're the plaintiff, so they bear their burden of proof. They have to put their evidence in first. And then when they're done, then you get to put your evidence in. Well, you don't normally get to sort of shove your evidence in while portfolio recovery is putting on their case. But under this rule, you do, because it's so important to get that full document in. So again, the reason I'm going over this in detail is, this would have taken 20 seconds to read, but I want you to understand the concept, the theory behind this. Why is this so important? Because we believe that whoever's making the decision, so a jury in a jury trial or a judge in what's called a bench trial, we believe that the trier of fact, the decision maker, needs to see the whole document unless the other side just doesn't say anything. So I'm telling you, if you're in a debt collection case and they put in the bill of sale, at least if it was me, obviously you make your own decision, but if it's me, I'm going to be saying to the judge, we have to see the whole entire document. Okay, I want to see all the terms of the purchase agreement. Because in fairness, you have to look at that. Otherwise, you get an inaccurate picture of the evidence. And the whole point of a judge deciding the facts or a jury deciding the facts is to get to the truth. Well, we don't get to the truth by just saying, well, here's one sentence out of my medical record from my emergency room visit on October the 11th, 2020. No, we need to see all the records that happened then. Well, we need to see the entire purchase agreement. So I hope you found this helpful. Let me know what thoughts, comments, questions you have. Put those in the comments below. And we'll be going through some other rules of evidence. And I've got some picked out that I think are pretty vital in a debt collection context. Now, there may be others that you see that you have a question about, and I'm happy to do a video on those. Just make a suggestion in the comments or reach out to me directly, and I'll be happy to add those to our list. Okay, guys, you have a great day, and I'll talk to you in the next video. Bye-bye.